Hearing is on the integrity of the patent and trademark system. Over 50 years ago, the people of Cuba entered into an era of religious prosecution, property seizures, and political oppression. Families who had worked for years to build a future for they and their families lost everything and were forced to flee the country, or worse than that, be imprisoned in Cuban jails. In response to Cuba's alliance with the then Soviet Union, its totalitarian dictatorship under communism, America began a trade embargo to deny Castro and his allies the benefits of free trade. In 1999, American policy further prevented the recognition by the United States government of trademarks seized by Cuba. A drafting error in Section 211, or what has come to be known as a drafting error, made the legislation subject to a challenge by those who want to do nothing more than, in fact, trade with the dictator. To fix the drafting error, I have become an original co-sponsor of the No Stolen Trademark Honored in America Act of 2015. The law simply would, the change in the law would simply take out references to a single country, but in fact still cover the category that would include the wrongful taking of these trademarks. In the case of the Havana Club example, a family business was seized at gunpoint with no compensation. Forced into exile, the family was unable to restart their business on their own and chose a partner with Bacardi, another company. The Ricard business of France chose to partner with the communist regime in Cuba and purchase and agree to distribute under the name Havana Club throughout the rest of the world. The United States, and I must say the United States alone, chose not to allow the sale and thus the profiteering by the Cuban government based on their theft. And let us understand clearly that we are still dealing with a Cuban-made product in which the people of Cuba work for maybe $20 a month to produce rum so the Cuban government can sell it at a price that benefits their regime. So the technicality that in fact we have a French government-owned, partially owned enterprise that will testify indirectly today that they bought it and of course they're simply entering into business is in fact inaccurate. In the case of the trademark in dispute, it was not a French company partially owned by the country of France, but in fact the Cuban government that applied for the trademark, the very Cuban government that had seized it illegally. With the passage of time, Cuban Americans also have sought to be repaid for stolen homes and businesses. On our second panel, we will have a former member of the claims board and a personal testimony of someone who is still trying to recoup that which was stolen from her family by this dictatorship.